So let's speak to the Executive Director of Access Chapter 2, and that's Steve Letsike. Mr. Letsike, thank you for being with us. How do you view this judgment today?
Look, I mean, this has been such a very long journey for us, in South Africa for the LGBTI community. I mean, many organizations, many LGBTI people have been aggrieved by this process. So this judgment came in at the right time where, the affirmation of the Constitution and the affirmation of judiciary is affirmed for LGBTI people. Of course, we know that John Qwelane's case, as it was reported from all these complaints, was inciting hate speech. And of course, this has been confirmed by the Constitutional Court, and we are quite excited and we are quite appreciative of what the judgment actually speaks on the matter of John Qwelane.
This wasn't clear cut. I mean, we spoke about this going through the courts, and different courts made different rulings, viewed it in a very different light. Do you think it's been good to really debate this issue?
Look, in times it's quite necessary to debate this because a length of judiciary has to be going through an exercise that affirms why inequality, and unfair discrimination has been experienced over time. You have to do this when some other people like your John Qwelanes have felt that, they were their own rights were infringed upon. So the idea of an unjust approach, or the idea of a just approach, you have to prove somebody that they were wrong and they were on the wrong side of the law and they've crossed the boundary. So indeed, it was necessary. However, I think where there's a great impact and effect is what has been experienced by LGBTI over time, and the effects that expresses themselves in terms of many harms and many injustices and many discrimination that LGBTI people find themselves. I think, of course, this is an old matter, that stems 13 years ago. But then if you calculate the extent of hate that has continued, and that sometimes people don't realize what is promoted as propaganda publicly may cause harm. So we need to actually even look at the deepness of this matter, of how much harm it potentially have caused over the years.
Does it really say where the boundaries are? Because we also, of course, have the right to freedom of expression, the right to religious freedom as well. Many religious people, Christians, Jews, Muslim people, may not agree with a gay lifestyle, say. Does this guide them on what can be expressed, how it can be expressed, if you have a differing view?
Look, the fact of the matter here, which we cannot ignore, is that, we have a constitution that also has an act around promotion of equality and the prevention of unfair discrimination. The law says everyone is equal before the law, and clearly stipulating some of the sections in the laws that speaks about why you cannot discriminate or do anything that potentially may harm others. Now, in the case where you speak about, what is right, what validates right for yourself based on your religion, your belief and so forth, may be right to you, and you may feel that, but as soon as it harms another and oppresses another, this is what is seen as unlawful in South Africa. What this country is quite clearly on, and that must be kept alive because of our democratic principles, is the rule of law. We can't negotiate rights in the case of what has been stipulated in our constitution. So while people feel that they've got freedom of speech, they've got freedom of expression and whatsoever, it must never harm another person. We have a history of prejudice in South Africa. We know what prejudice, we know what hatred, and we know what oppression has done to people in the past. We've seen it because of people of the, of black people who were oppressed. We've seen it of inequality between women, but we also consistently see it to the oppression that is expressed and experienced by LGBTI people. So these are things that we can't negotiate when it comes to the rule of law. Non-discrimination is what must be not be expressed, and we must understand equality. We must understand the rule of law and the human rights and dignity of everybody in this case. And I think Constitutional Court has affirmed that. And even if there's going to be amendment of section of the Pepuda law on the basis of section 10, it's around the word hateful. But the most important one, which is B and C, which speaks about how what can be uttered is more potentially can continue to cause harm and can incite hate in that regard, but also that we must never allow any propaganda or any promotion that may be harmful to another person or any group.
So very quickly there, because the one court said that the law wasn't clear enough. You're hinting at some legal changes. What could there be?
Of course, I mean, what it means is that, what has been in under Section 10A, which speaks about a hateful word, and it's what has been considered as whether it's vague or whether it's considered as overbroad. And that's what the Constitutional Court judgments clearly stipulate Parliament has a responsibility to review. And of course, it's about reworking the wording. It doesn't take away any other provisions of the Pepuda Act. It just says rework all these words, and you have 24 months to do so. And that's a responsibility another arm of state, which is Parliament, has to ensure that. But I think what is critical into affirming this judgment, it also calls on Parliament. Parliament actually has a responsibility. Over 2 decades, we've been discussing hate crimes legislation and hate speech. Now it's time. South Africa has to make sure that the hate speech and hate crime bill is in place. We cannot afford any life lost because of any reckless speech by anybody or any criminal act by anybody on the basis of hate.
All right, thank you for your time, and we'll follow that legal process now. Executive Director of Access Chapter 2, Steve Letsike.